Considering the widespread outrage, 2 petitions have been moved in the Supreme Court challenging the decision of the Gujarat government to grant remission to 11 convicts who had gang raped Bilkis Bano and had murdered her family members during the 2002 Godhra riots. One of the petitions has been filed by CPIM leader Subhashini Ali, independent journalist and filmmaker Revati Lal, and Professor Ruprek Verma. The petition was mentioned before a bench of Chief Justice of India N.V. Ramana, Justices Hema Kohli and C.T. Ravikumar by Senior Advocate Kapil Sibal and Advocate Aparna Bhatt with a request to hear the case tomorrow. CJI N.V. Ramana agreed to look into the matter but however did not pass any order of listing. He also asked the counsels if the convicts had been granted remission by virtue of a Supreme Court order. In response, Senior Advocate Kapil Sibal stated that the Supreme Court had merely given a discretion to the state government to consider the matter and that the petition was filed challenging the remission and not the order of the Supreme Court. The other petition has been moved by TMC MP Mahua Moitra, also challenging the release of all convicts in the Bilkis Bano case on remission by the Gujarat government. Filed through Advocate Shadan Farasat, the public interest litigation petition states that the victim has legitimate apprehension regarding the safety of herself and her family members. The PIL also mentions that the case was investigated by the CBI and thus the Gujarat government has no power to grant remission or order a premature release under Section 432 of the CRPC without the express concurrence of the central government. It also stipulated that releasing all 11 convicts on premature release on the same day clearly indicates that the state government has mechanically granted wholesale release without considering such individual case on merits. Arguing that the premature release completely fails to bolster either social or human justice, the PIL also contends that the exercise of the remission is squarely in violation of the Supreme Court judgments in Maru Ram vs Union of India and Sangeet vs State of Haryana. In Maru Ram case, the top court had held that the exercise of remission powers under the CRPC must embrace reason, relevance and reformation, as the determination of a convict's reformation is an inherently individual and case-to-case exercise. Similarly, in the Sangeet case, it had been held that the inbuilt checks on the power to grant remission must be faithfully enforced and that it was imperative to grant the same on a case-to-case basis and not in a wholesale manner. The TMC MP has also urged the Supreme Court to frame guidelines for grant of remission so as to channel the exercise of discretion and prevent its abuse. To provide a brief context into the developments, as India celebrated the 75th anniversary of independence on 15th August, 11 men sentenced to imprisonment for the gang rape of Bilkis Bano and the murder of 7 of her family members, including her 3-year-old daughter, in a communal attack during the 2002 Gujarat riots were released from jail in Godhra. Bilkis was the only survivor of the crime. The Supreme Court had ordered a Central Bureau of Investigation, that is a CBI investigation into the case after Bilkis Bano approached the National Human Rights Commission. Consequently, the Supreme Court in 2008 had ordered the trial to be transferred from Godhra in Gujarat to Maharashtra after Bilkis Bano complained of receiving death threats from the accused persons. In January 2008, a special CBI court had convicted 13 accused persons, out of which 11 were sentenced to life imprisonment on the charges of gang rape and murder. A 3-year sentence of imprisonment was also awarded to the cop who had initially refused to file Bilkis Bano's complaint. Thereafter, in May 2017, the conviction order was also upheld by the Bombay High Court. The Supreme Court, while also upholding the conviction order, had directed the state of Gujarat to provide 50 lakhs compensation to Bilkis Bano along with the job and accommodation. As the 11 convicts walked out of prison on 15th August, they were welcomed with sweets and garlands. The Gujarat government said that it had relied on its remission policy of 1992 to approve their applications for remission of the sentence and not the current policy of 2014. This was done after the Supreme Court in May this year, while hearing a plea by one of the convicts, Radhesham Bhagwandar Shah, for premature release, had held that the Gujarat government was the appropriate government to consider the remission in this case and had accordingly directed that the remission applications be decided within 2 months. The Supreme Court had also directed the Gujarat government to consider the applications for premature release under the policy dated 9th July 1992, which was existing at the time of his conviction. Following this, the Gujarat government formed a committee which was headed by the Godhra collector. The committee also included BJP legislators C.K. Raulji and Suman Chauhan, former BJP municipal councillor, Mulli Mulchandani and BJP Women Wing member Snehaben Bhatia. The panel unanimously decided in favor of the remission of those convicted and forwarded its recommendations to the State Home Department. Thereafter, the state government accepted the recommendation and allowed the release. Thank you. This is Aratrika Bhaumek for LiveLaw. Please subscribe to our YouTube channel for more such updates.